New Jersey has one of the most tenant-protective lease termination frameworks in the entire country, and it's built on a single foundational principle that makes New Jersey fundamentally different from almost every other state. If you own rental property in New Jersey, this is the most important thing you need to understand. New Jersey is a just cause eviction state. Under the Anti-Eviction Act, New Jersey Statutes Section 2A, 1861.1, a landlord cannot remove a residential tenant except for specific reasons listed in the statute, period. There is no such thing as a no-cause termination in New Jersey. You cannot simply give a tenant 30 days' notice and ask them to leave. You cannot decline to renew a lease without cause. You cannot terminate a month-to-month tenancy without one of the enumerated grounds. This has been the law in New Jersey since 1974, making it one of the oldest just cause eviction statutes in the nation. The recognized grounds for eviction under the Anti-Eviction Act include non-payment of rent, habitual late payment of rent, disorderly conduct, willful destruction or damage to the premises, violation of the landlord's rules and regulations, violation of a lease covenant, the landlord's desire to permanently retire the property from residential use, the landlord's desire to personally occupy the unit or have an immediate family member occupy it, the landlord's need to substantially renovate or demolish the building, and a few other specific circumstances. Outside of these grounds, you simply cannot evict a residential tenant in New Jersey. This means that in New Jersey, the concept of a lease expiration has a very different meaning than in other states. When a lease term ends, the tenant has the right to remain in the unit. The landlord must offer a renewal. And while the landlord can propose new terms including a rent increase, the tenant can challenge the increase if it's unreasonable. The only way to end the tenancy when the lease expires is if the landlord has one of the qualifying grounds under the Anti-Eviction Act. Let's go through the termination for cause procedures. For non-payment of rent, the landlord must provide the tenant with written notice and an opportunity to pay before filing for eviction. New Jersey requires a written demand for rent, and the tenant must be given a reasonable opportunity to pay. In practice, most landlords wait until rent is at least 30 days overdue before taking action, though the statute doesn't specify a minimum waiting period before the demand can be issued. Once the demand is made, the landlord files a complaint for eviction in the special civil part of the Superior Court, which handles landlord-tenant matters in New Jersey. The court schedules a hearing, and the tenant has the right to appear and contest. Even at the hearing, New Jersey courts frequently give the tenant additional time to pay, particularly if the tenant can show that they have the ability to catch up on the arrears. Here's something critical about New Jersey's non-payment process. The state has an extremely strong right of redemption. The tenant can pay the full amount owed, including court costs, at any time up to the moment the eviction is physically carried out, and the eviction will be stopped. This right of redemption applies even after judgment has been entered against the tenant. The only exception is for habitual late payment. If the court determines that the tenant has repeatedly paid rent late, the right of redemption can be limited. For habitual late payment, the landlord must demonstrate a pattern of chronic non-payment. This typically requires showing that the tenant has been late with rent consistently over a period of time. The landlord must provide written notice to the tenant identifying the pattern and giving them an opportunity to change the behavior. If the late payments continue, the landlord can file for eviction based on habitual lateness, and the court can limit the tenant's right of redemption. For lease violations, the process depends on the nature of the violation. For curable violations, like unauthorized occupants, pets, or noise issues, the landlord must provide written notice identifying the violation and giving the tenant a reasonable opportunity to cure. What constitutes reasonable depends on the nature of the violation, but courts generally expect at least 30 days for most issues. For disorderly conduct, which covers a range of behaviors from excessive noise to threatening or intimidating other residents, the landlord must provide a notice to cease. New Jersey courts require the landlord to document a pattern of behavior before the ground for eviction is established. A single incident of disorderly conduct, unless it's extremely severe, is unlikely to be sufficient. The landlord typically needs to show multiple incidents over a period of time. For willful destruction or damage to the property, the landlord can pursue eviction more aggressively. The landlord must provide notice of the damage and can file for eviction if the damage is substantial. The tenant does not necessarily have a right to cure in these cases, as the damage has already been done. For criminal activity, including drug offenses, assault, and other crimes committed on the premises, New Jersey provides grounds for eviction. The landlord must provide notice and can file based on the criminal conduct. For drug convictions specifically, New Jersey has enhanced provisions that allow expedited eviction proceedings. Owner move-in evictions are permitted under the Anti-Eviction Act, but the requirements are strict. The landlord or an immediate family member must genuinely intend to occupy the unit as their primary residence. The landlord must provide adequate notice, typically 3 months or more depending on the circumstances, and New Jersey courts scrutinize these claims carefully. If the landlord files for owner occupancy and then doesn't move in or re-rents the unit, the displaced tenant can sue for damages, and courts in New Jersey have awarded substantial penalties in these cases. For building demolition or substantial renovation, the requirements are even more demanding. The landlord must obtain all necessary permits before proceeding. The tenant is entitled to relocation assistance, and the landlord may be required to offer the tenant the right of first refusal to return to the unit after the work is completed. The eviction process in New Jersey goes through the special civil part of the Superior Court. The landlord files a verified complaint, and the court schedules a hearing, typically within 2 to 4 weeks. New Jersey requires landlords to attend the hearing, and the tenant has the right to appear, raise defenses, and request adjournments. Courts in New Jersey are known for being deliberate in handling eviction cases, and landlords should expect that the process may take longer than in states with faster